afternoon and welcome to the Influent Network. We have quite a show for you today. We have a very good friend of mine, Mr. Dave McCue. He's an attorney and he is a malpractice and contract attorney. And I've known him for many years and used him for many things throughout the years. I wanted him to come on today and tell you about things that can happen to you in your career that you're not expecting and what to do, kind of like pitfalls and pearls, to make sure you have a good, successful career. Hey, Mr. McHugh, if you wouldn't mind, please tell us a little bit about yourself. And thank you for joining us today.
Thank you, Doctor, for the opportunity to be with you all. I was born and raised in West Virginia, so I was a mountaineer, but I got to Texas as fast as I could. My mother was a med tech in a pathology lab, so I grew up in a path lab, and my father was a lawyer, so I spent most of my time putting law books away. I decided that I was probably not smart enough to pass organic chemistry or PChem, so I went to law school instead of medical school, but ended up with a good deal of experience in the medical field. I graduated with an economics degree in 1969 with a minor in finance and business orientation. Then I went to West Virginia University Law School after that. My first job out of law school was as a plaintiff's lawyer suing people. And that was turned out not to be something philosophically that I really liked to do. I didn't much like the cases, and I didn't like a lot of the people, which I'll explain later about why. But I was that way for about 4 years, and I also did criminal defense work, which was interesting, including a Watergate client that was never indicted, and defended the governor of the state of West Virginia in a racketeering case and got her not guilty. So it was an intriguing way to grow up as a baby lawyer. I moved on to become the senior law clerk to the United States District Judge in federal court in Charleston, West Virginia, where we tried multiples of cases together, and I assisted the judge, who then got promoted to the United States Court of Appeals in Richmond, Virginia, right beneath the Supreme Court of the United States. So I got to be a trial court law clerk. I also got to be a law clerk to a circuit court appellate judge, which was interesting. After that, I left the government and went to work as a business lawyer on the defense side of the bar, which is where my natural philosophy really was. And I've remained that way for 52 years now. So it's been an interesting experience. So I've worked with a healthcare law firm in Huntington, West Virginia, and we put business deals together. We assisted with financing, and we defended malpractice cases. Over my career, I've defended or been involved with more than 3,000 medical malpractice cases, including medical malpractice, medical products liability cases, hospital peer review, and Texas Medical Board cases. So I started off with manual typewriters and dial phones a long time ago. And now today we're dealing with artificial intelligence in the medical field. And everybody's impacted by the government, either as to fees or as to regulation. So it's been quite a wild ride. So that's pretty much how I got here.
That is quite a background. My gosh, it sounds like from covered wagons to jet fighters. All right, well, tell us a little bit about what's going on in your life today. What are you seeing today? Tell us a little bit about that.
Well, as I say, the regulatory world has become quite something with, for example, the Affordable Care Act and governmental regulation over fees, governmental regulation over billing. So today, part of my work consists of assisting physicians and other businesses in healthcare, the field, establishing new businesses, new corporations, vetting corporations, doing mergers, acquisitions, putting groups together, separating groups, corporate work, including forming corporations, participating in board of directors meetings and such, and a good deal in employment law matters. We currently assist physicians in malpractice cases with Texas Medical Board complaints, and I serve as outside litigation counsel for one of the large ophthalmic groups here in the North Texas area, assisting them with regard to any aspect of ophthalmic medical malpractice.
You know, I have quite a list of things here. You said a variety of cases. Why don't you start with something and we'll work from there. What is something that really sticks out in your mind?
Yeah, it's interesting because many doctors, when they first start out their career or they're just getting ready to end up their career, end up either with a medical board issue or with a peer review issue or end up being sued. And that's taken fairly personal by the physicians because you've dedicated your life to care, and yet all of a sudden somebody's poking you in the chest saying you done wrong, and either you ought to lose your license or you ought to pay me a whole bucket load of money. And that becomes very personal. So you have various different types of cases, like, for example, those cases that are frivolous or have no merit at all. And one of the reasons I stopped being a plaintiff's lawyer is a woman came to my office that had a husband who had a terrible back as a result of spine surgery that went wrong. And I'm sitting there talking to her, and I had just finished reading Larry Charfus's book on medical malpractice. And Attorney Charfus says, beware of anybody that comes into your office wanting to get you to sue somebody if they have their medical records in a paper sack. That means they've been to see another lawyer. And he turned him down. And it wasn't 5 minutes later, my phone rang, and in comes a woman from a different city with her medical records, her husband's medical records, in a paper sack. And he'd had an L4, L5 surgery, which supposedly had gone bad. And I asked her, I said, well, where's your husband today? And she said, he's having too much pain to come here. And I said, okay, he couldn't drive 45 miles to talk to his lawyer? No, he couldn't do that. And I said, well, what kind of problems is he having? And she says, well, actually, his back is somewhat bad, but he's losing his taste buds. And I said, what? He said, yes, he's losing his taste buds. And she holds up a mason jar, and she says, see, I vacuumed them up this morning, and here are all the taste buds. Obviously, I knew I had a problem on my hands, so I told her, I said, listen, I apologize profusely, but my partner, Stuart Caldwell, here in the next office, is the guy who handles taste buds. And it took him 2.5 hours to get the crazy woman out of my office. But
that is special. That right there, special.
You have cases like that they're frivolous and really have no merit. With tort reform, which we have in Texas, cases now have to be vetted by an expert. And if you're sued or you're in peer review, either way, within 180 days or within a set time frame, somebody has to give you an expert report to say where you did something wrong before the case progresses. And if it doesn't progress and the other side gets sanctioned, your attorney's fees. So there is a penalty now for bringing frivolous cases. It wasn't that way in 1972, but it is now, and that's a good thing.
That's a great thing. A lot of states don't have tort reform. If you want to elaborate a little bit more on tort reform, please feel free.
Sure. Well, briefly in Texas, conscious pain and suffering, that is all the difficulty that you have from amputating the wrong leg or operating on your brain and causing harm, etc., whatever it is limited to $250,000 in conscious pain and suffering. So there's a cap on monetary damages for conscious pain and suffering. The expenses and the lost wages are not capped. So what happens is within 180 days after filing a lawsuit, after the answer has been filed in a lawsuit, the plaintiff has to produce an expert report explaining how you breached the standard of care and how that caused harm. So it's sort of a gatekeeper function. And under tort reform, if you don't produce that report, then the case gets dismissed and the plaintiff's lawyer gets sanctioned with the attorney's fees. To file a malpractice case in Texas and really have merit to it generally costs the plaintiff's lawyer between $150,000 and $200,000 in experts' expenses. So it's a high dollar deal, and you don't want to have somebody have their costs sanctioned against you, especially if you're on a contingent fee. Tort reform has resulted in a tremendous reduction of lawsuits, and some of the cases that were more frivolous or less meritorious get kicked over to the medical board. We'll talk about that separately here in a minute.
Sure.
Great. The second class of cases you have are those that are meritorious. Like, for example, a doctor that, in a case we were in, got confused and took out the wrong lung of a patient, leaving the cancerous lung still in the patient, who later died as a result of that misdiagnosis. That's a meritorious case. Then you've got some third-class cases, which are cases in the middle, like the lady that had 360 spinal fusion, where they operated both anterior and posterior, put in rods and screws, and she developed a terrible spinal infection, which resulted in her being wheelchair-bound for the rest of her life. And we tried the case and were successful, but it was a meritorious case to bring. But the explanation for why she was infected was not our problem and not our cause. It was actually a hospital-based infection. You have breast cancer recurrence. We tried a case during American Breast Cancer Awareness Week not long ago for a woman who had originally had ductal carcinoma in the breast, and they had done a lumpectomy rather than a full mastectomy. And she later developed lobular carcinoma in situ, a second different type of cancer. We ended up proving in the court that the cancer was not the original cancer recurred because of any misdiagnosis. It was actually a different type of cancer. And we had a nationally recognized expert from Vanderbilt come down and explain that to the jury. And they accepted our explanation. But the case was meritorious to bring because they had expert witnesses to support them. They were simply wrong. The third and final case in this group is we had a child born over in Fort Worth at one of the hospitals. He was a Down syndrome kid. He was born prematurely by almost a month and developed a problem with what's called a volvulus, which is intestines starting to disintegrate internally, and they needed to go in and cut the intestine and take out the bad part and do an anastomosis and put it back together. And they couldn't get an IV line into the little boy's leg or into his groin or into his arm, because Down syndrome children don't have the same arterial structure that we have as regular non-Down syndrome people. So you may have a radial artery on you or I here on the radius side, but on them it may be in the middle of the arm, and it's difficult to find. So there was a problem at one hospital, and they ended up causing a medication to extravasate, and the little child's legs started to swell. So they transferred the child over to a children's hospital in that area, and it took 4 pediatric anesthesiologists 1 complete hour to get the arterial line in the child. And they unfortunately could only get it in the femoral artery in the groin of the leg that was swelling up. So the child had holes in his heart, both chambers upper and lower. So he had ASD, VSD, he had PDA. So his blood was all commingled between oxygenated blood and unoxygenated blood. And they got the art line in the leg that was swelling. Well, of course, the kid developed a clot, through a clot. Nursing staff and ICU didn't catch it until too late. So we were defending a case against a premature Down syndrome kid who had a leg amputated at the hip.
Oh, Lord.
And the question was whether or not the anesthesiologist did right, did the intensivist do right, did the hospital staff do right. So we defended the case and had a good expert witness who helped us, and that was a tough case as well. Then you've got the third and final category, or fourth and final category, which are what I call the national cases, and you see those on TV all the time. Years ago, it was the breast implants. And when the breast implants were rupturing and silicone was getting into women's bodies, was it really causing a problem? Was it an allergic reaction? Was it an immune reaction, autoimmune reaction? What was it? Now there's a whole chapter in the rheumatology textbooks about that very issue. You have the spinal rods and screw cases where people started doing spinal rods and screws in the back for scoliosis surgery and things like that. And people would put screws in the nerve roots and cause problems, paralysis, and, difficulty with the patients. And this past 3 years ago, we ended up with a case with a compounding pharmacy. And I'm not knocking compounding pharmacies, but a compounding pharmacy tried to make a nationally patented chemical, and they ended up creating an injectable that was supposed to be antibiotic and steroids that are put into the posterior chamber of patients' eyes to prevent inflammation and infection following cataract surgery. It's a fairly standard kind of approach these days. Sometimes they use drops, sometimes they use injections. Well, this group of people ended up making medication, and they sonicated it with sound waves instead of homogenizing it, as the national manufacturer did, who had the patented product. They ended up with chemical that went into patients' eyes that had acetone and formaldehyde in it.
Oh, no.
85 patients were blinded, unfortunately, by this medication. So it resulted in criminal prosecution, FDA, Texas Department of Health, and about 65 lawsuits when everything was all said and done over this. So the national cases that you see on TV all the time are oftentimes really taxing undertakings to prosecute or to defend.
Very good, sir. Now, the next section, and by the way, he gave us some notes, which are excellent. I'm going to see if I can send them on and put them on the podcast too, so we can have this for future. Now, I'd like to go into another section. He calls it advice to physicians that are and contracted by the Texas Medical Board. And this would relate not only to Texas Medical Board, but where any state or any place you are, if you're ever contacted by the state's medical board. And Mr. McHugh is very, very familiar with the medical board, and as well been to the medical board. And myself, I was on the Texas Medical Board Review Committee for 7 years. So I'll leave it to Mr. McHugh to tell us all about that and how important it is to have an attorney when you go before a medical board.
Well, the Texas Medical Board, by law, at least in the state of Texas, is charged with the obligation to protect the public against doctors that practice imprudently, improperly, or below the standard of care. So in kind of a backdoor way, if a complaint's filed against you at the Texas Medical Board by a patient or by a hospital or by somebody, some other colleague, they take the position essentially that, doctor, it's up to you to prove that you're innocent. It's not like you're presumed to be innocent until you're proven guilty, as occurs in the criminal courts. It's you're presumed to have a problem until you rebut it or explain why. So you need to understand that philosophically coming in. And the letter or the note that you'll get from the Texas Medical Board saying, "Dear Dr. Jones, a complaint has been filed against you at the Texas Medical Board. The specifics are as follows. On thus and such a day, you gave Sam Jones 4 times the normal hydrocodone that you should have given him in a prescription, and he overdosed on that, was hospitalized, and we believe you were below the standard of care." So when the medical board comes looking to you, most often they are either looking for an ethical issue or they're looking for a standard of care issue. And the first thing that you should not do is panic. The first thing you should do is call your medical malpractice carrier for attorney assistance, because most medical malpractice policies are twofold. Part of it is to defend you in a medical malpractice case if you're sued. The other part of it, they often call Mediguard protection, is to furnish you a lawyer to assist you with Texas Medical Board cases. So that's the first thing you should do, is get lawyered up quickly and get the insurance carrier to pay for your lawyer so they can start the investigation. The next thing you should do is not say anything until you receive competent legal advice. Remember, a fish doesn't get caught if he doesn't open his mouth. So the first order of business is don't talk or email or text anybody, any colleagues, any group, and certainly not the patient. So many doctors think, if I could just talk to the patient, I could convince her that I didn't do anything wrong. But that becomes almost intimidation if you call up the person and they filed the complaint. Your way to resolve that complaint is to take care of it at the medical board. Now, the other thing that's good to know, and it's different about litigation, is at the medical board, there are outside review physicians, such as Dr. Scott, who look at the cases independently. And then when you have the informal settlement conference in Austin, on Zoom usually, you have a medical doctor that sits as the chairperson of your panel. So a medical doctor has looked at this case, and before they decide to proceed, at least 2 doctors have looked at it and said, yes, there's a problem with this case. We would like Dr. Jones to come in and explain why he did the prescription in the manner in which he did. So the other thing you should do is to preserve everything in your office. Don't delete anything, including text messages. Don't delete emails, but obtain copies of all the medical records. And if the incident occurred in the hospital, get copies of the hospital records. If it occurred at a surgery center, get copies of the surgery center records. But don't attempt to interview witnesses until you've had the opportunity to talk legally with a lawyer about what to do and how he's going to approach it, because most lawyers will hire a private investigator. Read the complaint carefully and then try to figure out exactly what's being said about you that's wrong, because in many cases in the Dr. Jones complaint, it might say from the medical board, well, that we found that you were guilty of inappropriate prescription, but not mention what prescription, what day, when, where, how, or why. So you start your investigation, the state medical board starts its investigation, and you have access to the pharmacy, of course, to get whatever records are from the pharmacy, and usually you can figure out what supposedly the claim really is, because they tend to be oblique. And when you file a response, you want to be able to have a medical basis for what you're saying. For example, in the prescription case, it was not my error. I wrote the appropriate prescription, and here it is. The prescription that was given by the pharmacy was this one over here, and they doubled the prescription. This is a pharmacy error, not a physician error. So it just depends upon how you look with it, how you look at the case and what kind of an investigation you do. The one dramatic difference about the medical board versus a lawsuit, and I'll come back to this in a minute, but the one dramatic difference is expert witnesses really do count at the medical board. It's really designed to focus on, did you meet the standard of care? And that's really about medicine. It's not about how much hype you can push and put it in front of a jury, or how many did you consider type questions a lawyer can ask you on the witness stand, because it's materially different. You file your response with the Texas Medical Board, you have the informal settlement conference, you go down there, and although it's an adversary proceeding, the doctor gets to present his position, the state medical board presents their position, and then the medical board member and a public member meet, confer, and decide what they want to do. So it really is focused on honest medicine, and that's a good thing. And that should give you a little comfort, because remember, the most important thing you need to understand is that practicing medicine is a privilege, not a right. People in jail have a constitutional right to a free library. They have a constitutional right to a free lawyer if they can't afford one. People that are doctors accused before the Texas Medical Board don't necessarily have a right to a free lawyer. You have a right to a lawyer if you have one on your insurance policy. And if you don't, you have to pay for it. So we don't have the same constitutional rights as professionals. We have a privilege to practice. I do as a lawyer, you do as a doctor. So that's an important privilege to maintain. I guess that's the most important thing, is to figure out what is the medical defense that you want and who are the experts you're going to use to help you. We have a tremendous advantage today with UpToDate, the database that allows you to check quickly what the best care is and look at the resources and peer-reviewed literature that support it. So that's a tremendous resource today. It really levels the playing field between the good guys and the bad guys. Final point, I guess, on this is to maintain a calm demeanor throughout. If you take it personally because nobody challenges me on my medicine, well, yeah, somebody just did, and you get angry, that's a problem. Most often, if you get angry, whether it's in the operating room or with a patient or whatever, you end up paying a price for it. So don't ever let your temper get the better of you in dealing. Always be professional, because the people at the medical board expect it, and they don't expect to see anybody angry in Austin, no matter how grievous the charges are. And if you get way, way, way out of line down there, as Dr. Dunch did up here in Dallas, Dr. Death, and you can see about him on the YouTube thing with his surgical misadventures and his malpractice cases and his alleged drug addiction and his alleged alcoholism. It's a real problem if you're a neurosurgeon and you kill people and you injure and maim people. The medical board will take away your license, and that's exactly what they did with Dr. Dunge. So you're going to maintain your cool, maintain your professionalism, maintain your morality, and you'll be probably in pretty good shape at the medical board.
That's excellent. Thank you for that. While I have you, just switch a little bit, but the same kind of thing. A lot of us are on staff at hospitals. And so if a physician doesn't like you, you could be having to go before the medical executive committee, and you could be kicked out off staff. It happens. It's reportable to the medical board and national data bank. I mean, it's going to hurt your career. And so I'd like for you to expand upon that a little bit.
The field of it's called peer review, and that's separate and apart from the medical board. The hospital, by granting you privileges to practice medicine at that hospital, has the right, under the bylaws of the hospital, to evaluate whether or not you are a danger to patients or to yourself, or you're practicing below the standard of care. And if you have a ridiculous infection rate based on your work in the operating room, if you're deemed to be have alcohol on your breath when you go into the OR, if you're out partying, shooting allegedly shooting cocaine up the night before you do a neurosurgery, as in Dr. Dunge's case, and that's all, by the way, on the YouTube on Dr. Death, which is interesting to watch. It's terrifying, actually, because that really happened, and we were involved in those cases indirectly through an anesthesiologist we represented. But in any event, you can be called before the chief of staff, you can be called before the medical executive committee, and charges may have been assembled against you, and all of a sudden you're given an opportunity to explain why did you do this, why did you do that in the operating room, why did you do this to Nurse Jones, or why did you do this to Sally Smith in the hospital. As a matter of fact, I had a doctor not too long ago who was an anesthesiologist who'd practiced with a CRNA for some time. And he was walking down the hall, and the CRNA was sitting on the bench with her head in her hands and looking almost on the verge of tears. And the doctor walked over and knew her well, put his arm on her shoulder and said, "Are you okay?" And she looks at him and says, "No, thank you, I'm not." And he said, "Well, if there's anything I can do, let me know." And he just left and walked on down the hall. She filed a sexual assault complaint against him as he touched her on the arm. So oftentimes, nurses that don't like you can file complaints with the hospital, and those can be collected in a file and result in medical executive committee action. And as I say, if they believe that you're acting unethically, or they believe that you are a danger to yourself or someplace else, or some other patient, then they can suspend your license immediately. Then you have the obligation then to ask for a fair hearing, and that gets sent off to 4 or 5 doctors who sit and listen to your case, and there's a prosecution and a defense and expert witnesses and all that. And if you're found to have been a danger to yourself or to others, then you can lose your license. You can lose your permission to practice at the hospital permanently. And that's exactly what Dr. Scott was talking about, because that is reported to the National Practitioner Data Bank. The National Practitioner Data Bank does not go away. Once it's reported, it's there for all time. And once it's reported, all the other healthcare providers are now obliged to check the data bank. So when you get your first hit on the National Practitioner Data Bank, people like Humana, Blue Cross, Blue Shield, and so forth are knocking you off the provider list. So let's assume you're with a 5-doctor group, and all of a sudden, bang, you're off the anesthetic list. You can't get paid for doing Blue Cross patients anymore. You have to appeal internally within Blue Cross. But every time your credentials come up for review after a data bank, you're going to get thrown off the panel and have to appeal, thrown off the panel and have to appeal. So what you want to do is win the case at the peer review level in the hospital by presenting good expert testimony about what you did and why it was within the standard of care. And once you get thrown off the medical staff and you get a national practitioner data bank, it's an automatic report to the Texas State Medical Board, and that will trigger another investigation. So the whole thing is inextricably linked together, and it's sometimes difficult if people are angry or obnoxious in the hospital, in the emergency room setting, are perceived to be as such. And there are people who make up stories about people. We had an anesthesiologist not long ago walking down the hallway of the hospital and here in North Texas, and he and a scrub tech had been friends for about a year. During COVID, the anesthesiologist had gone to the hospital and insisted that they give them N95 masks because they were moving patients in and out of the OR that had COVID. And the staff, except for the doctors, the staff wasn't being given N95 masks. So the doctor insisted, to the disdain of the hospital administration, that they get masks. So the scrub tech said that was a really nice thing to do. So every time they saw each other in the halls, they would high five. And probably not the wisest thing to do, but the doctor was on his way to OR one day, and he was in a hurry, and he was carrying a piece of anesthetic equipment. The girl stands up and raises up her hand, and he hits her hand and comes underneath, comes sort of in an upward position like this, and hits her hand right about where the median nerve crosses and bruises her median nerve and her radial nerve in the carpal tunnel. And she ends up with tingling and supposed numbness and runs to the emergency room to be seen and treated, and goes to administration and reports it in AR. And the hospital told her to go file a assault and battery complaint against the doctor. And she did. And the doctor was had an assault and battery that he had to report on his public profile. And the case lasted for almost a year before we finally got it to jury trial. We tried it and argued that this was a high five among consenting adults. It was nothing more or less than half-assed horseplay, and they'd done it 13 prior times. Consequently, she got a sprained wrist and it healed. So it's not a problem. The jury was out 10 minutes, but the doctor had to pay privately for a criminal lawyer in my spare time and defend a case that arose out of peer review. So the moral of the story on peer review is keep your calm, keep your cool at all times in the hospital, because there are people looking to act against you. And to finish up real quickly, men joke oftentimes about women in the hairdresser salon. Why do they sit there and gossip all the time? Because they don't have anything better to do, and they're sitting there bored to death waiting for their hair to dry. But there's something more deadly than a women's hairdresser salon, and that's a police department, because they have too much time on their hands. They have too much office politics, and they make life and death decisions in a split second, and they're underpaid. So there's a lot of competition in a police department, but there's also a lot of politics. But there's a place worse than that, and that's a hospital. Because there you've got underpaid people and overworked people. You've got overpaid and overworked people, overpaid and underworked people, and lots of ego. And you've got people making life and death decisions in a second. So consequently, you have a lot of office politics in a hospital. Keep your mouth shut, stay out of the middle, don't get involved in internecine quarrels between people. Do your job and do it really, really well, because that's what the patients expect. So that helps avoid the problem of peer review.
Now, the other thing you said, you gave us some pearls. Let's finish up with the pearls that you came up with, if you haven't already discussed them.
Yeah, I haven't. Let me say one thing about malpractice cases, if I could, and then I'll move on to pearls. Everything that I've said before goes as far as litigation is concerned. But litigation, when you get sued, you take that really personally, because somebody has said you are a lousy doctor. And I had a friend of mine who was a lawyer that got sued for malpractice one time by a doctor whom he had helped out. And I saw the lawyer when he was in court, and he said, David, he said, I really know how my doctors feel. You sit there in the courtroom all day long and people are saying, you're no good, you're a bad doctor, you're no good, and I don't get to respond. Well, ultimately, you do get to respond. But there's 4 phases to a crisis. Denial. This isn't happening. I'm having chest pain, but it's not a heart attack. I deny it. Confusion. I'm having chest pain. What do I do about that? Do I go to the hospital? Nah, just an upset stomach. Anger. Damn, what is this problem I'm having with my chest? And then finally, action. And you either go to bed and wake up dead, or you go to the ER and get an EKG and find out you're having an MI. So you need, when you're sued, you need to get by denial, confusion, and anger. You need to move forward to action. That means getting a really good lawyer and making sure that you begin to formulate a really good defense. There's one thing different between the malpractice cases and the medical board, and that is the most important witness in the whole courtroom in any malpractice case is you, the clinician, because the 12 people on the jury most likely still do respect doctors. Lawyers and preachers are not quite in that category, but they do still respect doctors. And as a result, if you think about the 12 people sitting out there in the jury box as patients you're talking to, then talking to those patients means you talk in plain English, not in medicalese, and you try to explain the rationality of your position, why you did what you did, and that you're a caring physician. Expert witnesses are viewed by jury members as high-priced people that offset each other. The defense lawyers, experts paid. The plaintiff's lawyers, experts paid. Yeah, that's a he said, she said. But I'm going to go back in that jury room and decide if I really think that doctor cared, if that doctor tried, and if he was reasonable. That makes you the most important witness in the room, and you can't be in denial. You can't be in confusion. You can't be angry. You have to move forward in action. And that's the big difference, because they want money. M-O-N-E-Y, money. And the final important point on litigation is to remember there's 4 kinds of truth. There's what you think, there's what the patient thinks, there's what God saw, and there's what the judge lets the jury hear. And those 4 kinds of truth don't have to be the same. God doesn't get to testify. The plaintiff does and you do, and then we see what the judge lets the jury hear. So it's on you. So it's important for you to be caring, prepared, dedicated to the cause, and in an action mode. That's litigation.
Very good. Thank you. Let's finish up with your pearls.
Okay.
You might have already listed them, actually.
Well, but part of what's happening is today, because of tort reform, many cases are being pushed out of lawyers' offices to the Texas Medical Board. No, ma'am, I can't represent you on your taste buds case. You'll have to file that complaint in Austin with the medical board. And once you get a complaint from the medical board, you got to answer it. You got to respond. You cannot ignore it. If you ignore it, it will result in an investigation. Let's see. There are specialties, of course, such as neurosurgery, OB-GYN, some addictionology, some pain management that are higher risk specialties where you're much more likely to be sued than you are if you're a dermatologist or a plastic surgeon, although that happens as well, especially in plastic surgery with some of the things going on today, like Brazil butt lifts and misplaced injections. So that's kind of the way to look at where you're going to go and what you're going to do, and understand you may get sued somewhere along the way, because that's kind of part of doing business these days. Let's see, the vast majority of time that I've been practicing, which is now 52 years, I've seen juries reach the right decision in probably 95% of the cases that have been tried. But you need to understand that 95% of the cases are not tried, they're settled. The settlements are reported to the Texas Medical Board if it's more than $50,000, and they are reported to the National Practitioner Data Bank if insurance pays money under those settlements. So that triggers the whole NPDB thing that I talked about earlier. But if your odds are 95% that you're going to get a fair shake, then that's fairly important way of looking at, listen, I need to be engaged in the litigation process and participate in the litigation process. You need to know as much about the case, and you need to make sure that your lawyer knows as much about the case as you do. Plus, in the good news column, as a doctor that's practiced for many, many years, you've forgotten more medicine than the plaintiff's lawyer can ever learn, and you've forgotten more medicine that your lawyer can ever learn. So it's helpful to make sure that your lawyer understands it and can communicate it to 12 people on a jury that probably have never had high school biology under today's educational system. So you've got to be a teacher. And as the plaintiff's lawyer taught me when he first started with me, he said, David, the first thing about a jury is you've got to make it interesting, you've got to make it exciting, and you've got to do it in the first 15 seconds of the case. So in the case involving the young child, the Down syndrome child, the first thing out of my mouth was, ladies and gentlemen of the jury, there's two sides to every story. And I'm like Paul Harvey, I'm going to tell you the rest of the story. There's a very good medical reason for why this child lost his leg, and it has absolutely nothing to do with anesthesia. That's my story. I'm sticking to it. Watch me closely during this case because I'm going to prove it to you. And at the last part of the case, I was in front of the jury right before Christmas, and I said, the anesthesiologists in this case had their noses so close to that child that they were nose to toes, literally, on this baby. I took my shoe off and I put it in my mouth in front of the jury. I said, that close, nose to toes. And the jury cracked up and thought it was hilarious. But the anesthesiologist didn't do anything wrong. When they left the child's leg was not blue or damaged or hurt in any way. The clot developed later on and, could have been attended to, but it wasn't. And that was just simply not our fault. So a litigation case may take 2 or 3 years in intensity and in intense work. And it's a long, drawn-out affair that can impact you emotionally, impact your wife and family emotionally, your kids emotionally, and keep you up nights. The important thing is to bond with your lawyer and work like the Dickens to be prepared, because what you want to do is get on the witness stand and be smooth as glass. Forget about the judge because he's just a referee with a whistle. Think about the 12 people in the jury as 12 of your patients and talk to them that way. That's the way to win a case. So if you conclude that you do have a problem with the case, more than just he said, she said, if you really come to the abiding feeling that, I made a mistake on that, I shouldn't have given that medication, or I should have operated sooner, or I should have referred this patient to a different clinician, and if that caused harm, then the good news is that's why you have malpractice insurance. We're all human. God made every one of us, but we didn't get made perfectly, and we all make mistakes. If you make a mistake, the good thing is to have good insurance to protect you under that set of circumstances, because then you can go to sleep at night saying, I may have made a mistake, but I settled the case and I did the best I could to make it right.
Well, thank you, Mr. McHugh, for your time today. It's been a pleasure and an honor. I really appreciate the insight that you've given all of us, and I hope the medical students and the residents understand that how important this is to have someone that you can lean on and talk to. And then there is that possibility that you will get sued or you'll get reprimanded or something like that, but don't lose hope. Main thing is today is not to lose hope, because you're wrong. And that's why Mr. McHugh is there. And that's why he's made a good living from doing it. So thank you, sir. Thank you for today. And I appreciate everything you do and look forward to having you again sometime.
Well, appreciate the opportunity to be here and to talk to both doctors and residents and interns and so forth. Thank you very much.
Thank you.